So the solution that the moral philosophers arrived at was we should give lawyers the moral responsibility for the actions that are taken in legal representation. We should, allow their professional duties to be sort of tempered or changed and shifted according to what the lawyers believe is right and wrong. That way we can reintroduce sort of ordinary moral responsibility and judgment into professional decision making. We'd encourage lawyers to be setting limits on their legal representation based on what seems right to them, based on their own moral compasses. And if legal representation were shaped by the moral judgments of lawyers rather than these partisan duties to these clients, it would prevent harm from coming to innocent third parties. It would permit lawyers to be good lawyers and good persons at the same time. And that's the solution that the moral philosophers basically came up with. And it's a good solution if you accept their premises, their assumptions about moral lawyers and cardboard clients. If you take away the assumptions about moral lawyers and cardboard clients, there are some fairly obvious problems with this solution. For example, if you assume that lawyers and clients are kind of equally capable of making good moral decisions, it doesn't make a whole lot of sense to give lawyers a veto over their clients' decisions. Because after all, the decisions that are made in legal represent are going to represent whose life? Clients. There's no reason to believe that lawyers' legal training and expertise gives them special, sort of moral expertise. And our democratic system, upon which our legal system is based, is based on the idea that we're a government of laws, not men. And that means, in terms of the lawyer-client relationship, that really, in terms of political theory, clients ought to be able to pursue their objectives within the bounds of the law, the legitimate legal limits, not within the bounds of their lawyers' moral compasses. And when you further consider that we actually live in a morally pluralistic society characterized by fundamental moral disagreement over some foundational values, the idea that a client's affairs ought to be governed by the lawyer's moral compass becomes even less defensible. You have to imagine that the client is a human being who walks into the lawyer's office with a human problem or situation. Someone who's been injured on the job, wants to file for divorce, has just fired an employee and now has been sued for wrongful termination, someone who wants to start a business and doesn't really know what kinds of regulations and procedures apply. And what the lawyer does when that client walks into the office, what the lawyer's been trained to do, what you're being trained to do in law school, and what you're gaining expertise in doing, is to sort the facts of that very human problem into legal categories. And probably more than one set of legal categories: claims, defenses, procedures, evidence. The lawyer issue spots the client in much the same way that law students learn to issue spot the facts on a law school exam. And in the process of this issue spotting, the lawyer distills the legally relevant facts and determines the strategies or structures that the law provides for pursuing the client's objectives. Now, in this process, if the lawyer is not careful and attentive, the actual human client can kind of disappear as a human being with a human problem and appear instead to the lawyer as just a bundle of legal interests walking around in a human body. The client's sort of important non-legal interests, the client's relationships with others, the client's reputation and standing in the community, the values and commitments that the client wants to honor, can fade into the background as the client's legal issues and rights kind of come into focus, sharper focus in the foreground. As a result, lawyers have a professional tendency to overvalue the client's legal rights and interests relative to the weight that the client might assign to those rights and interests when the client compares them to the things that the client actually values. Now let's add to this picture the fact that protecting our legal rights and interests almost always involves maximizing our wealth and freedom and power at the expense of others. And then we start to see something really interesting. Because I've been criticizing the moral philosophers for assuming that clients are just these cardboard figures who want to take advantage of other people and are impervious to moral restraint. But now we see that in the practice of law and in the very process of employing legal expertise, lawyers are in danger of doing something kind of similar. They're in danger of overvaluing their clients' legal interests and disregarding the other values, relationships, and commitments that the clients might bring to the table. And from the outside, that can look a lot like zealously pursuing the interests of selfish, grasping clients to the limits of the law. But even though they might look the same, look similar in terms of the lawyer behavior, the problem that's at the heart of that behavior is really quite different. The problem of lawyers issue spotting their clients we aren't really imagining that clients really are interested in only maximizing their wealth, freedom, and power. We're imagining that the lawyer's preoccupation with the client's legal rights and interests has caused the client's other concerns to kind of fade into the background. So the solution that we're going to seek is not to turn over moral control from the client to the lawyer, because the lawyer is a more moral person than the client. But the solution is to get lawyers to bring the client's other interests and concerns back into the picture so that the legal representation can be directed around objectives that put the pursuit of the legal interest into the context of the client's other values, relationships, and concerns that are of concern to the client. Now, what I've just described there is the client-centered approach to lawyering that forms the centerpiece for most teaching about professional skills of interviewing and counseling, and is really the established orthodoxy of teaching that goes on within clinical legal education. Now, the client-centered approach to lawyering was also developing in the mid-1970s, around the same period of time that the moral philosophers in legal ethics were exploring these conflicts between role morality and ordinary morality. And it can be seen, as I said, as addressing the same basic problematic behavior, but coming up with a different solution. Now, I'm a proponent of client-centered representation, client-centered lawyering, both because I think it's a better diagnosis of the problems in legal professionalism and because I think it's a more attractive solution. It's a more attractive solution because it allows us to reintroduce moral responsibility into legal representation through clients. It provides a source of limitation on the lawyer's no-holds-barred partisanship that springs directly from and is consistent with the lawyer's professional duties to pursue their client's objectives, rather than from making appeals to lawyers' moral compasses that kind of compete with professional duties and undermine the values of autonomy and dignity and equality and the rule of law in our democratic system that the lawyer's traditional roles are based on.